Let's take a look at hearings in administrative law. The APA provides for elaborate adjudicatory hearings which are triggered by separate statutes or constitutional due process. Coverage does not extend to decisions based entirely on inspections, tests, or elections, military and foreign affairs, and some additional matters. When adjudication is required, persons entitled to notice of an agency hearing shall be timely informed of the time, place, and nature of the hearing, the legal authority and jurisdiction under which the hearing is to be held, and the matters of fact and law asserted. Hearings are to be scheduled with regard to convenience and necessity of the parties and their representatives. The agency must provide the parties the opportunity for the submission and consideration of facts, arguments, offers of settlement, or proposals of adjustment when time, the nature of the proceeding, and the public interest permit. Federal employees who preside over adjudications have several different titles and levels of skill and independence. For the sake of convenience, they can be considered under two broad headings: ALJs and all others. The title administrative law judge replaced the hearing examiner in 1972. Whatever the name, the main concerns with ALJs have always been impartiality, competence, and efficiency. The problem of ALJ impartiality is complicated. Despite their independence from agency hierarchies, ALJs are part of the organizations in which they work. They're likely to share many organizational goals and values. Their response to political and media criticisms of their agencies may be identical to those of other employees. Association with an agency, especially over a long period, is likely to have an impact on their worldview and judgment. Neither the APA nor procedural due process requires that ALJs preside over all types of adjudications and hearings. Overall, there are more non ALJ presiding officers than ALJs. Many of these are not insulated from the agency's hierarchical authority. They may be hired and fired like other employees. Most do not work solely as adjudicators. Their performance has not been systematically tracked, and they may be considered the real invisible judiciary. On occasion, an agency commission or board may preside over the hearing stage of the case, though usually its role is to hear appeals or review recommended decisions. Under the APA, ALJs and other hearing officers make initial and recommended decisions at agency discretion. Initial decisions are generally issued in ordinary cases and become final rules unless they are appealed within the agency or reviewed by it.